Legal analyst Mpumelelo Zikalala from Zikalala Attorneys joins us for a discussion on the next step for the Department of Correctional Services to ensure that former President Jacob Zuma does indeed go back to jail to finish his sentence. Mr. Zikalala, always a pleasure to see you. Thank you for joining us, sir.
Good evening to you, and also good evening to your listeners.
All right, let's start here. I mean, and that is the question, I suppose. Say for the fact that the former president at this time isn't in the country, should he at this point be rearrested?
Not at all. I think when we listen to the order that was issued yesterday, we must look at it from two bases.
Yeah.
The first one is the technical basis of saying that the court was simply saying we did not. The Commissioner did not have the powers to release the former president. On that basis, what would ordinarily occur if there was still some time attached to the sentence, which is attached to a particular individual, to return back and then continue serving the sentence up until such time you are eligible for parole. But here we're dealing with a unique circumstance where you have someone his term has practically ended. And if you're going to consider the time in which they have spent while they were in correctional supervision, which already they are detained because they don't have the liberty of going anywhere in which they want to go to, then you could say that the sentence has been done and dusted. Even if you want to interpret it in another sense and simply say the ConCourt was simply saying any time which is spent outside of the time which the former president was out is not going to be considered. There are ways and means of taking into account the amount of time that has been spent by the former president. The Correctional Services Act is very easy, and it does give powers to the commissioner to then say there's temporary leave which can be granted to a prisoner. There is community supervision which can be granted to a prisoner, but that is subject to the Community Supervision Board approving the step. There's also parole which is available, but that is subject to the parole board taking steps. But there is a mechanism within the Correctional Services Act that allows the commissioner on his own to then say, I'm going to grant this particular prisoner certain amounts of leave, which are not determined, by the way, as to what's the maximum amount of leave which can be granted, to then say, go and reintegrate back in the community. I want to take into account of the fact that at the time in which you were in question, or your release was in question, you were at the end of the day a prisoner, and we should afford you that particular time in which you spent as being a detainee.
Mr. Zikalala, speaking of irregular circumstances, how often does the correctional services, in fact, get involved in situations like this? I mean, they, of course, applied for leave to appeal against the Supreme Court of Appeal's decision. Does this happen regularly?
No, not really. It's very rare, and especially in this case, it was one of those unique circumstances in which I think even the SCA wanted a bit of help from the Constitutional Court to say, here are unique circumstances that we are being faced with. Can you please come to our assistance and show us the way as to how we ought to interpret this type of manner? And it also points to the ConCourt. I think the ConCourt was correct in one part, but missed a very important step or duty to then say, how can you protect the interest and the rights of the former president in this case? Let's look at him as a litigant, not even as a former president. Here's someone who then says, I was let out of prison, out of someone who I thought had all the powers to do so, and it turns out in which they were performing an illegal act. So why should I suffer from the decision which was taken by another person? When, if you look at it at the end of the day, despite the fact that I was outside the bounds of prison, I was still a prisoner, so my freedom was still deprived. So if you then say to me I must come back, which is a practical implication of what the ConCourt orders actually states, it means that you're going to add an extra amount of months within my sentence, which was not issued by the ConCourt earlier. So at the end of the day, the one person who's going to suffer more is me as a litigant. And when I've been to the ConCourt, I expect the ConCourt to protect my legal interest by making a determination as to what's going to happen to that time.
There's still this train of thought that the former president, was arrested without a trial. And if one is to use that particular train of thought, then we could also then say the ConCourt seems to be confirming the stance of the Supreme Court of Appeal and justifies the decisions made there. What sort of precedent, in the long term, would this then serve if people are of the view that this was an unfair process and that there was no trial?
Let's separate it into two instances. The first one is to say the scrutiny of the decisions which were taken by the commissioner. The ConCourt was very clear in terms of saying, you as a commissioner, if you're going to take on a decision that needs a separate board to sit, if you take that decision without that board sitting, and you must know that whatever decision that you've taken as a commissioner is definitely invalid. Which is why it's important that whenever there's a community supervision board that needs to sit, a parole board that needs to sit, a medical parole board that needs to sit, it must sit before you take the decision. Otherwise, whatever decision which you are going to take will be regarded as being invalid. But the second part of it is, in instances of a contempt of court proceedings, the court was very clear in adopting the system of saying it adopts a unique circumstance, a unique procedural aspect in which ordinarily, whenever transgression has taken place, a matter would start within a lower court and make its way up until it reaches the ConCourt if it needs be.
Yeah.
But in instances in which you have defied a court order or an instruction of that particular court, it is that court in which you have defied the instructions from which is going to issue the punishment which is equitable to you. And part of that punishment may even include you being incarcerated for a certain amount of months for being in contempt of court proceedings or being in contempt of court. The reason or the type of harm that you are trying to prevent is instances in which people are going to disregard instructions from the court because they know very well because there are no consequences which are going to be suffered.
Yeah.
What was a bit harsh was the sending of the former president to direct imprisonment without an option of affording an opportunity of remedying the defect or the cause of complaint which might have been stated by the State Capital Commission. Ordinarily, in almost all cases in which I've read, in contempt of court proceedings, a last opportunity is given to the offender or to the alleged offender to then say, if you fail to comply while you are giving you this last chance, then the consequences of going to jail are going to follow. But in this case, it did not follow in that manner. And the court was quite clear in terms of saying, the way in which you've defied the previous instructions, it is clear to us that you are going to defy whatever instruction is issued to us. That's incorrect because you are then insinuating that and taking into account or reading into evidence which is not there.
Yeah.
Wait up until the offender has offended and then you can punish them with sending them to jail. So it was a bit harsh in that instance. But in terms of the procedure which is being followed, I think the procedure was quite correct. Whenever offender has or contempt proceedings or contempt act or conduct has taken place, it is up to that court to then say, here's how we are going to correct it. To say to it must go to a lower court, go to a police station, be enrolled as a case matter and be charged separately. It certainly defeats the purpose and it's going to take a very long time up until that court that needs that person to listen gets an opportunity or gets a grip on the offender so that they're able to do what the court is telling them to.
All right, Mr. Zikalala, always a pleasure hearing your legal analysis. Thank you very much for giving us your time here on SABC News. Mpumelelo Zikalala.